Why don't we get started? I think because of the holiday, we're going to have a little bit smaller group than we've had the last couple of weeks. So don't be shy. So folks come on up front. Before we get started with our today's presentation, though, let me just ask everybody to turn in make sure that you turn in your thesis statement. So, Susan? Okay. So she's ready to get your, so I think that's the one piece of business we have, right? Susan, is that it? Yes. Today we've got, I'm going to let, just as we talked about last week, this is a really interesting subject that, this gets at, as we talked about the different ways to think about health law, which about the intersection between intellectual property, regulation, and how that affects health and health outcomes. And so we've got a terrific pair of speakers today. Let me just introduce one of my colleagues, Professor Jay Thomas, who is an expert at intellectual property and health issues. And in his second job, he also works for the Congressional Research Service and helps them look at some of these issues too. So he's very much involved in these issues. I'm going to let him introduce himself, the subject, and his colleague. I just want to thank you both for looking forward to it.
Well, thanks a lot, John, and thanks a lot for coming today. Mr. Glass, did you just show up for extracurricular? Okay, well, it's obviously his first month here at law school, I can tell you. But no, it's very kind of you to come on this warm day, and I'm very pleased to introduce my dear friend, Hans Sauer, who is so he was on the other side of the lectern for a long period of time. He's actually teaching a course in intellectual property and health, essentially.
Pharmaceutical patent law in the spring.
Pharmaceutical patent law. So he's been such a good friend of Georgetown, so no good deed goes undone. But we've hauled him over here on this warm day to engage us in issues with respect to follow-on biologics. So here's what I plan to talk about. And again, I just want to say welcome to my world. This is a very complex field of law. I introduce you to a fair amount of it. I don't consider myself much of a public health specialist. In fact, my background is in computer engineering, and as a patent person, we tend to segregate ourselves. So normally people like me are doing software and business method patents. But this was most interesting to me, health, because this is where intellectual property affects us most in our everyday lives. These are the most important intellectual property rights. But you'll find it's very complicated. So let me do my best to try to lay out the basic scheme, how patents work, and then we'll talk about the fact that in health, it's not a garden variety patent statute. It is a patent based on specialized laws in the United States, laws that the U.S. has been very aggressive in exporting to other jurisdictions through diplomacy, as in Europe, and through the heavier hand of free trade agreements, certainly throughout the Americas and increasingly in Asia. So when you go home, if your home is elsewhere, you may bump into this. But then I'm going to ask Hans to introduce follow-on biologics because he knows a lot more about it. In fact, he's got a PhD from Lund. He's got a PhD from a Swedish university. And if you speak any Swedish, you know that people from Lund speak of, it's almost incomprehensible, right? It's very old-fashioned. It's like a very old-fashioned. So Hans, maybe you can show some of that off. But I neglected to mention Hans, in addition to his JD from Georgetown, has a PhD in neuroscience and had worked at Genentech, a number of different drug companies, really at almost every phase, it seems, almost at the lab bench, more in managerial tasks. Most recently at Guilford Pharmaceuticals in Baltimore, which is a diaspora of people in high places in our patent society. So, Hans, you can talk about that too if you want. But anyway, we're grateful to have him here today. And to the matter, which is, what is the extent to which we ought to encourage these drugs through specialized intellectual property rights called marketing exclusivities? It may seem like a fairly rarefied debate. It's one that's very active right now, and this is something that's really on the ground. It's going to control access to medications, really through pricing, but it's also going to hopefully incent. And of course, as you look around, we're confronted with an enormous dilemma. So many indications, so many diseases for which there's no medicine available at any price, but also the notion that a drug that's not affordable cannot possibly be safe and effective. So this debate really centers the classic property tries to solve. We want to encourage labors of the mind. We want to encourage innovative products that make our lives better. But at the same time, we want to promote access. And trying to strike that balance is a very tricky task for legislatures and courts. And I think throughout this debate, we had to remember that one person's incentive is another's limitation. And it's most keenly felt in the area of health. So, in pharmaceuticals, patent medicine that's not commonly used today. And when we think about the patent system, we think about the pharmaceutical industry, right? There's no industry we can name that's more patent. When I teach patent law, and Mr. Glassman is actually suffering through the semester so far, when I teach patent law, I say, hey, you get patents, they go on for a certain period of time, they give exclusive rights, and at the end, they expire, and you can have free competition in that field. Well, to be honest, it really doesn't work like that in most fields. No company's not built a hybrid car because of patents. Okay, Toyota has not sued Ford for patent infringement. They've talked about their patent disputes and they've made a deal. Okay, so it's true for computers, plastics, really just about any other industry. There's not too many times that patents really shut companies down, like BlackBerry, right? We were on the precipice of shutting down our BlackBerry service, and they made a deal. But you're not going to find many deals like this in the pharmaceutical. It really works. The patents last for a period of time, and when they expire, there's free-flowing, and the prices drop drastically, right? So it really works in this area. And of course, another thing about the pharmaceutical industry, it's just so. Those firms are so engaged in such a risky proposition. It's amazing how many compounds are screened, how many go through preclinical trials and then clinical trials. You read that in the newspaper, right? This drug that seems so promising flunked trials. It's amazing the amount of money that goes into compounds that we never see. So the ones that get through the process actually have to support the rest, right? They have to prop up the R&D for the others. And so obviously there is a patent reliance on the patent system to fund. And it gets very tricky. Now, how does the patent system work? Now, most of you, I guess, have never seen a patent, and you're probably happier for it, right? You've never actually read a patent instrument. So let me just give you the 10-cent tour. So, Mr. Glassman, you'll know the whole thing. You can stop attending class now, because you'll get the whole thing. But how does patent acquisition work? Aren't like copyright, where rights arise spontaneously. A few of you are actually taking notes. And I'm sure you're aware, you've got copyright in your expression, right? You don't have to do anything. The U.S. actually runs something called a copyright office, but it's really just a filing cabinet. People register their rights there, and they do so really just for purposes. There's an infringer later. They're able to prove I'm the author, this is when I did it, here's my proof, that sort of thing. There's no obligation to register your rights. But it's very different in the patent system, because patent rights don't arise on their own. You have to seek them, and you have to get them from the government. And here that's done through the United States Patent and Trademark Office, which is a large agency. It's been sort of shunted off to Virginia at this point. But it used to have a very handsome facility right just a few blocks away. And what examiners do, and you've probably heard the phrase patent examine, right? These are officials who review the application to see if it meets substantive patenting requirements. And although there are a lot of these requirements are most worthy of note in this context. One is the utility. So to get a patent, you have to identify your use for the invention that you're claiming. Of course, if you're claiming a hammer or a wheelbarrow or a new metal, there's probably a lot of uses. It's not that hard to come up with a use. But of course, for drugs, and especially biological compounds, sometimes it's more difficult. It turns out that in patent law, it's a much more lenient from the FDA. Remember that the FDA is going to look to medicines, and they're going to ask for information showing that the drug is safe and effective when administered to patients. But you don't need that kind of advanced showing in the patent holder. You really just need a much more minimal statement or in a minimal proof that this drug is effectively promising, that it possibly has indications against a particular disease. Now, Hans, if you have any comments or want to correct me at any juncture, and if anyone has any questions, by all means, raise your hand. So all you have to show that this is possibly effective, that there's some proof, usually through lab experiments or animal experiments, showing that it may lower blood pressure. It doesn't have to be safe and effective. It's a much lower standard than what the FDA imposes. You don't have to show that you could actually administer it safely to patients, just that it. Now, also the invention has to be non-obvious. It must not be obvious to a skilled artisan. So what we ask is, could a skilled pharmaceutical chemist come up with this drug without a lengthy R&D process? And if it would have been obvious to the skilled person, then we don't allow the patent issue. And that seems pretty clear, right? We shouldn't allow patents on inventions that we can already come up with, that really already lie within the state of the art. So those are, again, two big requirements. There's a bunch of other ones, but they don't have much. Now, when you get a patent, what do you get? What did you pay for when you went through the USPTO? Well, if the examiner allows your patent to issue, what you get is the right to exclude. It's a cause of action in tort that you write for yourself. You say, I'm the only one who gets to sell these. Okay, it's like a regulation, and it's yours for all over the country. Now, we must contrast carefully what the USPTO gives you versus what the FDA gives you in a marketing approval. The patent right is effectively a negative right. You get the right to exclude. You can prevent others. But it's not the right to do. Okay, that makes sense. If I get a patent on a handgun or a nuclear missile, I can't freely go around building and using that kind of stuff, right? There may be some government intervention to regulate me. Similarly with drugs. Doesn't mean I can actually sell the drug. In this country, the FDA may be very concerned about my ability to market the drug, and I may not be able to do so without that agency's approval. So again, patent is the right to exclude, the FDA is the affirmative right to do. Okay, so we have to distinguish those. And the term is 20 years from the date of filing. So you don't actually get any rights until the patent issues. The clock starts when you file the application. In a sense, every day at the patent office is a lost day. Effective term, when you can actually go out and sue people. Now, like most rights, patent rights aren't self-enforcing. There's not a government agency that goes out and enforces the patent for you. Rather, you have to go around identifying your competitors, and if you think they're practicing your patented invention, you need to confront them. You need to write a cease and desist letter. You need to have perhaps a more collegial communication. But ultimately, if push comes to shove, you go to patent litigation, which is exclusively in the federal. So you basically accuse another of infringement, and the courts decide whether you're right. And it turns out Congress thought so much of patent cases, or the other courts really didn't want to do them. For whatever reason, the Congress set up a specialized court of appeals. So it turns out we have one court here in Washington that handles all patent appeals from around the country. And those patent appeals then proceed to the Supreme Court if the court chooses to grant certiorari. You get the typical remedies. You can get damages for your lost sales. Also, typically, although not always, the court will enjoin your competitor from practicing the patented invention until the 20-year term expires. Okay, so is that clear? That is good? Okay. Now, if you thought that was bad, okay, we have to take all that as a given. It turns out the pharmaceutical patents are not subject to your typical patent code. Okay, it turns out there are a lot of specialized provisions that govern pharmaceutical patents. And it turns out in this country they cover a few other things. They cover medical devices, they cover pesticides, but actions in drugs. And the reason for that is that Congress enacted a specialized statute. It's what the Drug Price Competition Act of 1980, once called the Waxman-Hatch Act, now commonly known as the Hatch-Waxman. And it does a lot of things. It's a very complicated statute. The things are specialized enforcement provisions. It creates specialized patent term provisions. And in fact, it even created a whole new genre of intellectual property rights as recently recognized by the World Trade Organization. So, how did we get to the Hatch-Waxman Act? I think it's best sort of to bring out an historical description. So let me take you kind of a long way around the barn, and once we figure out where we were, we can decide where we are now. And there's a big case. It's a 1984 decision, Specialized Appeals Court that does patents, the Federal Circuit. And even though it was in 1984, plainly it's their most important opinion. At least I think it is. Because it creates a whole new specialized statute, and it's something we've exported. This law has gone around the world. Now, Roche, the brand name drug company, holds a patent, and they also have Dolmine, which is a sleeping pill. Never that popular in the U.S. compared to other jurisdictions, right? We're not a big sleeping pill country. But in the early 80s, the sleeping medications were making some inroads. And the patent, that's why you attend lectures like this, I guess. The patent is going to expire in 1984. So, Bolar, which is wants to sell a generic version, wants to sell its own version of Dolmine. Okay? We're all familiar with that, right? If you don't have a prescription, you probably have an older relative who does. Familiar with the notion of generic drugs, right? Me Too drugs, sort of off-label, sold by generic firms that are putatively copies of the brand name, right? Basically, it's the identical active ingredient. Now, Bolar seeks to market a generic equivalent, so it goes principally to Italy, I think, and buys the fine chemicals it needs to whip up its own versions of Dolmine. Now, Bolar wasn't very secretive about this. Okay, in fact, this became something of a test case. Okay, Bolar was sort of, we're going to do this, so Roche sued them for patent infringement, and it goes through the court system. Now, what Bolar says is that I ought not to be liable for patent infringement in this case, and the reason for that is I'm not dispensing pills to patients. I'm not selling to pharmacies. There's no actual end consumer who's actually taking my version of Dolmine. What I'm doing is just trying to get FDA approval. Okay, to get FDA approval, just as Roche had done some years before, I need to submit lengthy evidence of clinical trials to the FDA. I have to do preclinical stuff. I have to get different phases of human trials, at least 3 phases involving more and more patients. Some that don't have the illness, some that do. I have to track side effects. I have to present all sorts of evidence of the chemical characteristics of the compound, its shelf life, its toxicity. I have to do so many studies, and it's going to take years. So I'm just doing these experiments pursuant to FDA approval. I'm not actually selling them. Again, I'm not going to sell until the patent expires, but I want to line everything up. I want to get everything ready for the FDA to approve my application. So this is, and what Bolar relied upon is a doctrine in U.S. patent law called the experimental use privilege. Now, many of you, I'm sure, are familiar with the fair use privilege, even if you're not from the United States. Right? You probably have this fair use privilege in copyright law. And depending on your country, your author's rights statute might have very specific provisions. If you grew up in the U.S., you probably wrote a term paper or in high school or some college paper. Lots of block quotes, right? In fact, you have to do a paper for this class, right? So you've got to fill the 30 pages somehow. You have lots of lengthy quotations, little quotations from others. And how did you do that? Why didn't the copyright owner come sue you for infringement? Song in the recording industry will come after you, right? So, hey, how bad can it be? So how are you able to do this? Well, it turns out our copyright law, at least, has a fairly robust fair use privilege. And so what that does is allow academics, students, critics, really just about everyone to borrow from the works from others in limited measure. Okay, and it turns out it's in our copyright statute. It's fairly broad privilege, depending on the use you're claiming, academics and historians than competitors of the author. So Bolar said, look, this is analogous to fair use and copyright law. I ought to have something fairly expansive here. But the federal argument, it says, look, this isn't a true experimental use. You're not doing this for philosophical, scientific purposes. You're an intended competitor of Roche. You're not doing this just to enjoy yourself. You're doing this because you want to compete, and this has a direct competitive impact upon Roche. So the experimental use argument is rejected. And it was a big holding because in the pace of congressional discussion about what we ought to do about pharmaceutical patents. Because the opinion was perceived as leading to twin distortions, two problems. Okay, one problem that brand name firms said they had is that, look, we have to get FDA marketing approval too. And as I told you, patents sort of start at a certain term and they end at a certain time, right? Well, the patent clock is running while I'm pursuing FDA approval. Okay, I can't stop the patent clock. It just keeps on ticking. So if I have a 20 and it takes me 10 years to get FDA approval, I've only got 10 years left. Okay, so I've suffered. Okay, I have substantially less term than people who make other sorts of patented products. I get a substantially less effective term than some. Semiconductor manufacturers don't have to get government approval to sell their products. But I sell drugs, and even though, yeah, I still get, in theory, I still get 20 years. I mean, there's still 20 years there. But the first 10 just got consumed because I couldn't sell any products. Okay, so that was perceived as a problem. Another problem was that faced by the Bolars of the world. That is generic firms. Because under the Roche v. Bolar holding, they too had to go through the identical new drug application process, the lengthy period of clinical trials. And so they were not able to start those trials until after the patent expired. So they also were in a position, look, we can't sell, the patent's expired, but it cast a long shadow. If it took the brand name 10 years to get marketing approval, it's probably going to take me 10 years to get marketing approval. So it effectively extends the patent term. Now, of course, pundits like me say, aren't these effects self-canceling? But Congress didn't see it that way and ended up talking about the Hatch-Waxman. Okay, Hans. Oh, Hans. Okay, that was too much for Hans.
No.
All right, so let's see.
Just quickly, I want to stick something in here. It is of what happened to Bolar. Right? And you ask yourself, is that the kind of thing that could be other industry? I think the question is still out there. In other areas of commerce, patent law actually accepts the notion that you can't, if say you're a semiconductor manufacturer and you want to be ready to flood the market with your own microchips the day the innovator's patent expires. Patent law, in that area of commerce accepts the notion that no, you can't, the patented microchip and stockpile it and only start infringing, if you will, on the market the moment the patent expires. It's the concept of it's the tapering out of the patent that in many industries, except the pharmaceutical industry, is accepted as residual protection, if you will, that patents provide. So in here, in the pharmaceutical industry, I guess once we got to the point where we said, okay, we're going to make a special rule for generics who essentially suffer the same conductor manufacturers and everybody else suffers. And we're going to do it because it's of particular public benefit. Right? We want the generic to be ready on the market on day one. And in order to do that, they have to be able to test, to manufacture, to stockpile, and ship on the first day. Now that's a societal benefit that we want to apply, particularly in the health area. So we're going to create a special rule for generics. And that only worked with the brand name pharmaceutical industry because you had this canceling out effect of the special rule that was then created for the brand name manufacturers in the form of patent term restoration. Does that kind of, fill in the gaps?
No, fair enough, Hans. Okay.
Because I want to drive home the creation of special rule upon special rule upon special rule from one to the other that makes this area of patent law so complex that you have a separate group of practitioners really who only deal with that. To the extent you run into pharmaceutical patent attorneys and you think they're not quite normal, it's because they don't practice normal patent law.
Okay, all right, thanks. Okay, well, chime in, because now we're getting to the more difficult terrain. Okay, so what did Congress do with the Hatch-Waxman Act? Remember, twin distortions, brand names say, the patent clock's running, but I can't sell my product, so my effective patent term is diminished. And as look, I have to wait until the patent expires to begin doing my clinical trials. And so that effectively means the patent term is extended. So what did Congress end up doing? Well, the first thing it did is said, okay, well, brand name firms, we tend to agree that your effective patent term is diminished. So what Congress in one of the most of the federal code is as a patent provision. Okay, and in a nutshell, because there are many exceptions, brand name firms can get up to 5 years of term extension. There's also a 14-year cap. So their effective term, where they have both marketing approval from the FDA and a patent, 14 years. Okay, the average tends to be with a relatively complex formula that's presented. Okay, so they say Congress will give you some of your term, not all, but some of your lost term back. And that's just days that are added to the very end of the patent. Okay, so there's just a period of extension. Now, in addition, Congress effectively overturns Roche v. Bolar, but in a very limited way. It says, and this is a provision that's very complicated, and the Supreme Court has construed it recently in a series of, or at least two, difficult opinions. But what it says is, at a minimum, generic firms are allowed to tinker with patented drugs under the patent, and that cannot lead to a charge of patent infringement. So there's a safe harbor. In a sense, there is an experimental use privilege that's granted in favor of generic firms. Okay, so those two distortions are solved. So we're done, right, with the Hatch-Waxman? Well, there's a lot more going on, and let me just mention a few of them. One of the biggest innovations, or let me say, one of the biggest changes, we'll try to be very neutral. One of the biggest changes is that Congress set up an expedited generic approval pathway. Okay, so again, prior to the Hatch-Waxman Act, if you wanted to sell a drug in this country, some of them get off the hook, it's complicated, but you have to, and again, I mentioned the series of lengthy tests that have to be done. If you actually printed them all out and put them, they would probably fill the back of 6 or 7 pickup trucks, or maybe a Mayflower moving van worth of paper. It's enormous quantity of data. So what Congress did instead is there's an expedited generic approval pathway. So if you're a generic firm, you're allowed to rely on the data that was generated by the innovator. Of course, the innovative firms, the brand name firms, of course, had kept this as their trade secret. And the FDA would also maintain that data as a trade secret. So what Congress effectively did is take away that secrecy to a degree. You know, if you're the generic firm, you don't actually ever see the data. It remains secret. You don't look at it. But what you essentially do is rely on it by indirection. You say, well, I know the FDA just approved Prozac, and I'd like to make my own version. So the data must have been good. So I'm going to rely on that data. I don't actually see it. I don't know what's in there, but it must have been good enough for the regulators. Now, what you have to do then is essentially say, and I have to choose my words carefully. Generic drugs are often not precise. There are some differences. And in fact, when laypersons learn about some of the differences that come up, they're actually surprised the term generic is used at times. That was a battle that was fought and lost by the brand name firms. They're having a better luck in the biologics arena where they've stamped the word generic out, as we've seen. But essentially what you have to show is that the active ingredient of the drug is absorbed into the bloodstream at the same rate, within some margins of error, before a group of volunteers. So it's usually 12 to 20 healthy male volunteers are assembled, and they all take the generic drug, and then they just check the rates in the blood, which usually means measuring your blood. Is that pretty much it, Hans? And then at that point, if there's a similar bioabsorption rate, the generic is deemed to be the same.
Pretty much. You know, if your molecular entity is also the same, you know, on everything else there's fair wiggle space. Bioequivalence, which is what Professor Thomas just described, and the molecule is the same. You know,
The active ingredient.
The active ingredient.
Right, okay. Because remember, when you bind it, this is a very complicated thing. It's got all sorts of ingredients. It's got excipients, it's got binding agents, it's got a lot of different components. And those don't have to be the same. It's just the active ingredient has to be bioequivalent. That has to be the same.
But you can get exceptions. You can file a suitability petition. Certain variations. But some things the FDA won't let you under, won't let you out of.
Right.
And that is bioequivalence and sameness of
Dimers are a common playground for that,
different
right?
salts. They will allow you to do that, but you know what's really like the molecule that really trips your receptors or whatever it is. You know that must be the same too. So it's these two things: bioequivalence and the same molecule. Everything else may be varied if you get permission.
Okay. All right, so fair enough. So that's what generic drug is. So again, obviously it's much quicker to generate that and the extensive work. So the average answer, it's much less than 2 years. It's more like approval of approving an ANDA as compared to an NDA, which the NDA has not been approved until the 20-year patent has expired. So the patent is gone. Okay, so and you finally get FDA marketing approval. Now, in addition, this is really beyond our present purposes. There's also a very elaborate patent dispute resolution proceeding. And in short, the way it works is name firms are invited to list all the patents that they have that cover the drug in an FDA publication called the Orange Book. And the Orange Book, I think, used to be or was the descendant that was really used by pharmacists. So to say, okay, if it's a generic drug, here are some AA equivalents, here's some AB equivalents. In other words, this one's really close, this one's similar, but has a different method of delivery. At least from my lights, the Orange Book. Because what happens is brand names are invited to list their patents. Now, I've started to use the word patents now because I'm going to get more sophisticated. I was saying patent before. Many of you, I think, are naive and think that there's one patent covering a drug, right? There's a pill you hold in your hand, there's one patent, right? But in fact, that's seldom the case because, in fact, patent attorneys are able to define their inventions as they see fit. You're given the ability to draft patents as you wish. And so many inventions have multiple aspects. And some believe that in the pharmaceutical arena, this has been taken to a very high art form. But commonly, you'll have a patent covering the active ingredient. You'll have a patent covering the formulation, which is the active ingredient whipped up with all the other components. So you have a pill that you take. You have a method of making patent, which is how it's actually produced. You have a method of medical treatment. And on an isomer or polymorph of the original, in other words, a chemical variant of the original compound. It gets very elaborate. You may even have patents on the metabolites. That is, when you take the pill, the processes of your body often will convert the active ingredient into another compound. Once brand name companies figure that out, they'll patent that too. Now, there's been a lot of inroads from the courts about doing that. Courts have been very chary about those kinds of patents. But the original idea was infringement by digestion. Right? When you're generic drugs sell the pill, patients take it, they're generating in their bodies, and so you can get them from that. So at least many of those patents. When a generic firm files its ANDA, it must account for those patents. They have to state their views. You have to say, well, there were some patents, but they've all expired. Or there's some patents, and I'm going to wait until the patents expire. But the action begins if a generic firm says, I see some patents there, I think they're invalid. I think they were improvidently granted by the patent office. And again, patents are it's presumed to have done its job in terms of meeting requirements like utility and non-obviousness, but it's not an incontestable presumption. And so generic firms will often challenge the validity. although the figure is controversial, but the FTC recently concluded that generic firms prevail in 74% of the validity challenges. They're often not challenging the good upfront patents. They're often challenging more of the downstream, weaker patents later in the life of the product. Now, in addition, generics can say they don't infringe, often because they may have a different formulation or a different way of packaging that active ingredient. If that happens, the brand name firm may bring a charge of patent infringement, not against the actual product that is out there, but against the filing, the ANDA itself. The act of filing the ANDA is deemed a patent infringement, and there can be a patent infringement suit right at that time. And the idea is to bring a quick resolution to patent disputes. Whether that aspiration's been achieved is another matter. Okay, now, we've finally gotten to what we're going to do in the main, which are marketing exclusivities. Okay, marketing exclusivities are a new form of intellectual property right. There actually was a statute earlier that created one form of them. But the Hatch-Waxman Act really brought them forward. And what these are a special property right that applies to pharmaceuticals. Now, adopted in Europe, in fact, Europe adopted slightly longer versions of them, I'm sure Hans is happy to say. Every WTO member arguably has to have some form of marketing exclusivity or some form of protection for data that's submitted with respect to drugs. In addition, the U.S. has been very aggressive in this in its free trade agreements. And each FTA we've subsequently signed has more U.S.-like law with respect to marketing exclusivities. Of course, the deal is when you sign the FTA with us, the FTA matches our law already. So we don't have to change anything, but you do. Okay, that's the deal. All right, so what are market exclusivities? How do they work? What's the situation? There's quasi-patents, and they're administered by the FDA. And what's great is they're administered automatically. Okay, the owner of the market exclusivity really doesn't have to do anything, except for once in a while kind of, prod the FDA in case of a disagreement about entitlements. Okay, but generally the owner does nothing. They're administered by the FDA. And as the word exclusivity suggests, their effect is that they exclude or they protect their owner, the brand name firm, from competition in that market. Now, I said there was an earlier statute that actually set this up. And Larry and John, I used to be able to make jokes about the Quincy TV show, which is how this came up. This is a very young-looking audience. Okay, there's a few people who are willing to admit they've actually saw reruns of this back in their misspent youth. But there was a TV show about a medical doctor and condition. In this case, it was Tourette's syndrome. And you can't make fun of diseases in this seminar, but it's the notion was there were promising treatments against this indication, but no one was willing to actually obtain marketing approval. It was just too expensive, and the target population of patients was just too small. So because there was no expectation anyone can make any money out of these products, they were so-called orphans, because no one would be willing to adopt them. Okay, no drug company would be willing to do it. So Congress, in response, passed something called the Orphan Drug Act. And again, you see essentially the same legislation in Europe now. Now, the notion of the Orphan Drug Act is if you have to show that this indication, or sorry, this disease or condition has less than 200,000 people, but there's no way they're going to be able to recoup their investment costs. So if you're able to make that showing, the FDA will grant you automatically a 7-year period of orphan drug exclusivity. So what that means is, and it's fairly limited, but what this means is if someone else comes up with the same drug for the same disease, the FDA will put that application on hold. It will not allow that marketing approval to issue until the 7 years have expired. And now, though the Orphan Drug Act, it seems like it's fairly limited that are very well known today, in fact, enjoyed orphan drug exclusivity. One of the biggest ones is the best-selling biologic ever, erythropoietin. The number one it was the number one expenditure of the U.S. government of any drug. In fact, enjoyed orphan drug exclusivity. So some of the drugs scheme and then having broader application. So again, it's sort of like a 7-year automatic patent. The proprietor doesn't have to do anything, the FDA automatically enforces. But again, it's fairly limited. If you try to, if you go to the FDA with the same drug for a different indication, and with some other disease or condition, it's not blocked by the orphan drug exclusivity. Or you can have another drug for the same condition, and that's also not blocked by the orphan drug exclusivity. Primarily focused proprietary interest. And it's really intended to serve the purpose, which is just to bring out orphan drugs and to help that orphan drug owner enjoy a period of exclusivity. Okay, now what about the Hatch-Waxman Act? Okay, so it creates additional exclusivity, so what exactly are there? Well, there's 3 of them. Okay, the new chemical entity, studies, and generic exclusivity. So let me just talk about them briefly in a row. Now, the new chemical entity exclusivity lasts for 5 years, and it has to be new. You have to come with a new drug, which means it can't be the same active moiety of the drug the FDA previously approved. Okay, so it's basically got to be it's got to be a different chemical. I'll just leave it at that. For the patent wonks out there, like Mr. Glassman, who just went through the novelty portion, it's not the patent law new. Okay, in other words, it's entirely new or different than what came before. It just means the FDA hasn't approved that compound before. This is the most robust exclusivity we have. This is, if you can get this one, it's the best. You're probably the best you're going to get. It lasts for 5 years, and this exclusivity actually prevents the FDA even from receiving a generic application. The FDA cannot even accept the application from generic competitors. If you get such an application, it's supposed to either, I don't know what they do now, their practices always change back. Maybe they're sitting on them now. I don't know how it works, but they can accept the application. The term is the 5 years plus the time it takes the FDA ultimately to approve the ANDA, right, which could be a year, 2 years. So that's the effective term. Pretty good situation. Most drugs you've heard of probably got the new chemical entity. And statins, well, that's a different matter, but most of the drugs you probably heard of have enjoyed this exclusivity. Now, if you don't get a new chemical entity exclusivity, you can still get a new clinical study exclusivity, which is 3 years. And that's somewhat weaker because it doesn't actually block the FDA from accepting applications. It just blocks them from approving the application. So the FDA could receive an application and process it. If the 3 years haven't expired, it will issue a tentative approval pending the end of the 3 years. Now, basically, you get this if you don't qualify a new chemical entity. Okay? But many products enjoy both a new chemical entity exclusivity initially, and during the life cycle of the product, they enjoy some of the new clinical study exclusivities. So, for example, if you have a new dosage, okay, you went from the pill to the patch, okay, study. Another one, of course, that's common is going to over-the-counter. That kind of new clinical study exclusivity. So it's a little less robust, but an exclusivity that blocks generic competition. And finally, there's the good old generic exclusivity. It turns out you don't actually have to be an innovator to get an exclusivity. And what this is intended to do is ameliorate collective action problems that are associated with patent challenges. That's a very fancy phrase, isn't it? Let's say that Hans is the patent owner. So we've got the Hans brand name mega drug company sitting here in the front row. And each of us is a generic firm, right? Now, we think that Hans's patents are bad. And we think, we think this is low-hanging fruit, and I can challenge these, declare it invalid, and I can selling a generic drug and make millions. Now, what's the problem with that situation? In terms of, there's all of us, and Hans has the patent. Now, I don't know about you, but I'd rather have somebody else do the work, right? Why should I challenge the patent when I can get John to do it? Or maybe John will do it for me. And, of course, the issue of patent validity is patents are valid or invalid as to all the world. So if John goes through all the work of challenging Hans's patent, he has to effectively share his success with everyone else in the room. And Mr. Glassman, you're a nice guy, but forget it. I'm not going to do this myself. But of course, John's probably thinking the same thing, right? So at the end of the day, the patents are never challenged. There's a public goods problem. associated with these challenges. So what Congress said, in a fairly complicated provision that has had some interesting interpretations, the first generic firm to challenge enjoys 180 days of exclusivity. In a sense, there's a duopoly. Congress intended a duopoly. So the patent gets challenged, hopefully that challenger strikes it down. If it's good, it stays. But if it's weak, it's struck down. And at that point, the generic firm would reap basically a 6-month duopoly. And of course, we know how brand name, higher prices, duopoly, the generic can charge a certain price. Of course, when everybody comes in, the generic price drops even lower. Okay, that's especially true for small pharmacies, though it's much more sophisticated today. But back in the day, of course, the first generic, again, got the slot on the shelf. Okay, and they would just keep buying from the same generic rather than perhaps another company. So anyway, that's the generic exclusivity. There's one more exclusivity, which is the pediatric exclusivity. I've only got 3 more slides before our break. Everyone hanging in here? I have to wear a tie. Well, you've got a couple of guys here. All right, but anyway, there's also something called the pediatric exclusivity. Okay? Now, the pediatric exclusivity is intended to encourage better labeling of drugs for children. Now, if you read a lot of over-the-counter or other products, they've never been tested on children. And the reason is, informed consent. How do we get kids to tell us how they feel? I mean, it's tough. It's not something drug companies often want to do. And so the problem is when a child would come down with a certain ailment. There was a drug out there that worked for adults, but what do you do for kids? You cut the pill in half. Children's bodies sometimes adults. So there was a lot of concern that we had a robust pharmacopoeia, but we weren't really directing that toward children. So the notion is with this exclusivity is we want drug companies, we want the sponsor, the brand name drug company, on children of the drug. And so the way it works is the FDA approaches the brand name firm, often I think with a bit of urging by the brand name firm, because this 6 months is a pretty good deal. But anyway, the brand name company is approached by the FDA and requested to do a study. And if the brand name firm completes the study to the satisfaction of the FDA, then they will receive 6 months that are added to every exclusivity they've got. 6 months of the patent, they've still got a new chemical entity, you get 5 years, 6 months. You got a new clinical study, we'll add 6 months to that. Everything that. And the notion is, again, just to perform the test. The test doesn't have to be successful. The test could show, boy, you better not give this to anybody under the age of 12. Okay, it doesn't actually have to be anything positive in a sense. But so long as the study's done, then you get the exclusivity. Again, it's intended to encourage this kind of study. Okay, well, look, that was the 25-cent tour of the Hatch-Waxman Act and the myriad exclusivities. How about life after Hatch-Waxman? Well, supporters of the bill say, look, this is a fabulous, it's an incredible example of legislative intervention that really worked. R&D as a percentage of sales from the industry has increased markedly. So the sense is with real generic competition waiting on your doorstep, it lights a fire under you, right? You've got to keep moving. You've got to reinvest some of those profits back into R&D because generic competition, you're always looking at it downstream, and you need to come up with another drug in the pipeline. New chemical entity approvals are way up. Okay, there's more approvals, although some say that the next few years look a little more bleak. But the idea is, at least in the history of Hatch-Waxman so far, new penalties are way up. And in fact, despite all of that, we've had tremendous generic drug penetration in this country. I mean, arguably, we really didn't have a generic drug industry. We had a handful of very thinly capitalized, really fly-by-night operations. Their ability to make drugs you really want to take was a little suspect. Now we've got an extremely sophisticated, large, and robust generic industry, and every year the number of generic. On the other hand, the revenue share of the brand names remains at 84%. It's still going to the brand names in large part, but of course on the ground we're enjoying a lot of savings. So again, supporters of Hatch-Waxman and its basic framework, it's complicated. The act's been fantastic. But there's also concerns. Just a few. I've mentioned the notion of evergreening. Remember I mentioned all the different kind of patents that can come out? Well, they often don't come out at once, right? You sort of have your active ingredient patent, and the pattern just seems to be sort of as that 20 years is kind of winding down, 20 plus 5. Other patents start coming out, okay, on new formulations, on isomers. There's also been concerns about swap outs, right? A company has one particular drug, and then they withdraw it as generic competition in years, and they bring in a close substitute, something that's very chemically similar, that leaves the generics about a reference product to frame their approvals under, but also sort of swaps out the whole patient population to something new. So there's concerns about evergreen. It's called life cycle management too, I guess is a more neutral terms. Hans, what do you think? You've got sort of a you're reflecting there in the front row.
To let you finish. I'm biting my tongue.
Okay, I see. Okay. Okay. Let me just finish this, and we can get the reply. There's also concern about industry abuses. The statute was heavily amended in 2003 to handle some of them. Some of the things we're dealing with now are authorized generics. Remember that the generic company that's encouraged. So say John actually does challenge Hans's patent, he gets the 6 months. Well, what's been happening now are the so-called authorized generics, wherein the brand name either it sells it under its own generic arm, or cozies up with another one of you, and says, "Hey, you could sell a generic product." So all of a sudden, and that's called the authorized. Same pills coming off the same assembly line, except they're put into a white box of a slightly different name. And so the generic, rather than enjoy, has to face another generic competitor, one that's often come out a couple months before it's approved. Okay, so it's a way of sort of one of the interesting Waxman is it relies a lot on private incentive structures to perform public goals. And of course, the actors who are regulated under that regime don't always behave nicely. Okay, they're capable of collusion. Okay, they're capable of acting in their interests that Congress didn't think about. Another problem we're having are reverse payment settlements. In fact, I think it's really the FTC's problem because they're bringing a lot of suits and losing constantly. But normally in patent cases, when I was a patent litigator, I would sue. This is an electronics largely. And we'd sue and they'd come up and say, well, look, we really don't want to see this thing through to judgment. It's risky. We're going to spend a lot on lawyers' fees. Let's make a deal. Now, in those cases, money would change hands. And guess who would get the money? It would be the patent owner. Right? The accused infringer would pay the patent owner to go away. Right? I mean, that makes sense, right? But that's not what we're seeing in Hatch-Waxman cases. In Hatch-Waxman cases, what we're seeing is there's an ANDA filed by the generic that says we think these patents are weak. The two parties, and there's a settlement. But the brand name company, the patent holder, is paying the accused infringer to go away. Right? Now, how can that be? Well, antitrust lawyers say, well, look, I'm familiar with with market segmentation and collusion of this nature. But others say it's in the nature of the Hatch-Waxman Act. Name share is huge, right? If you have just a single entrant in that category, they get a larger profit share. If a generic comes in, well, the whole market might shrink something like this, right? So the brand name says, well, look, take a piece of this pie. This piece is a lot better than the piece you're going to get in this pie, and I'll sort of pay for a period of time. Sometimes the entire term of the patent. Sometimes they split the term. Those settlements have proven very controversial. But so far, most courts have upheld them, saying that it follows naturally from the structure of the Hatch-Waxman Act. An ANDA, but they really have nothing to lose. Right? They're not like a competitor in electronics that's got a factory, is selling, has customers, doesn't want to get cut down. The ANDA has nothing to lose. The brand name has a lot. It's only natural that money would flow in this reverse or counterintuitive way. All right, well, look, you've been very patient. So I think we let Hans have his rebuttal, why some of these things are still fresh. And then we take a break? What do you say? Oh, actually, here's a question first, though.
I just have a quick question. You had mentioned that the R&D as a percentage of sales increased after the act. Is that, is that on new drugs, or is that on coming up with an improved version of the drug that the generic?
I think it's just firm by firm, so they haven't sliced the R&D up that way. Okay, is that it? Anything else? Okay, Hans. Oh, there's more. Do you want to hear Hans first, and then you go? Or this is more factual, sir?
Just on that question, how is R&D defined?
Well,
So is it real research or is it marketing?
I haven't dug down into the study. Obviously, the economist who did the study did his best to figure out what was laboratory scientist salary, et cetera, rather than sales and marketing. Okay, these numbers are pretty. A number of studies have been done that are fairly consistent, but I haven't drilled down into the study. I'm a lawyer, not an economist. Tell me anything. So, was there anything else, sir? Okay, Hans. Okay, you want to grab the lectern, or are you happy to?
Louis, or does everybody want to take a short bio break? I realize we've been going for an hour.
Do you like the phrase bio break? That's right. What do you think?
Does the audience know who our works for? Have I been introduced as such? Anyway.
No.
If you hold on, you'll probably take a few minutes. Why don't we take a break if you want to?
Do you want to just introduce your topic? Introduce your topic.
Introduce my topic. Okay, what to expect during the next hour?
The real story.
Yeah, I work for the biotechnology industry organization. So I'm not with Big Bad Pharma. And the people I represent, the companies I represent, 1,200 of them, are for the very most part small entrepreneurial, but far from the market, who wish to one day make as much money as the companies that we've been talking about, some of whom are also but the vast majority. So I think, one thing that brings us here today is that we're asking ourselves, what are we going to do? Having seen all of the things we do in the generic drug area, last pieces of legislation we've created, what are we going to do in the whole space of biologics? I guess it's going to be the topic for the next hour. There's no piece of legislation that so far has created generics in the space. And biologics, I'm going to explain that a little bit, are different from small molecule drugs in that they, by and large, they are made in living organisms. So they're made in cell culture, either bacteria, yeast, or for the most part, eukaryotic cells, so mammalian cells on a large scale. Cell culture and therapeutics are with typical vaccines. And they can be enzymes, they can be antibody therapeutics, receptor agonists, and so on. But they are all. Does it get better if I talk into this thing? And so these are not small chemical molecules that are made in a factory. Maybe this helps. But they are made in bioreactors, and that makes them very different structurally, scientifically, and that has implications for their regulatory approval and the way the FDA handles them. So I would just want to leave you with that notion that biologics are a whole different therapeutic class. They're administered by a different center at the FDA. And all the rest we'll talk about after the break.
Technology. We'll fix the technology.
Yes, where's that?
It's electronics. Okay, I think it's our signal. Do you think we're crossing the signal? Okay. Well, you can just turn the signal off. Why don't you turn that one off? How do you turn it off? You have to hold it? Yeah.
You have to hold it to turn it off.
I don't know. Oh, I'm out.
So maybe I'll just get away further from the
I don't know. That's really.
Walk up and down the aisle.
And you're at the Hopper short end or something.
Well, that's kind of. I was just using my Wi-Fi to see if that causes a.
If that's such as unplug it.
The only downside to that is that too, but that doesn't.
Oh, no. I know. I didn't say. That's all right. I'm sorry.
We can shut that down too, so I'm sorry. Yeah, it's a crazy, I didn't. Got here last year. They have this ability to fill every classroom remote. But you should, I do believe that it's very easy to hear, so that's why it takes.
Anyway.
Okay.
Just let's do it next.
Actually, I'm used to like funny with
Because you can see the cameras right up there, so.
yeah.
I think as long as you're in there, I think that works exactly. Now, you know, in case you do need anything, that's a good file. Okay. Well, thank you. This is perfect.
Waiting to
Yes.
There's actually something years previous which looked at the lesson and then actually
Really nice guy. I know he went to Bible. Everyone's like, it's like one of these ones here.
that it's still based.
I'm good. Well, I am actually taking a looking nice and slim.
Even penetrating the numbers.
Oh, that's good. So you don't have to go that far.
Pretty free. So really that's not.
This is just a small token of appreciation.
That's small.
Just came out.
We should at least give out.
Actually, basically trying to and increasingly so yeah, that's trying to work I don't think yeah, but you can
Thanks, there. do your spiel, then we can just talk about it.
Different, complicated, can't make sense.
Yeah, right. Okay, then
These are the current states. Then we're going to tell them, we're going to try and create that.
Then you can spend 1 minute and do it a little differently. So no,
So do you want me to like talk about like say about how we're going to create a pathway? Then we want to get into data.
right. And then I'll just do my spiel. What do they do? And then you can have your rebuttal, and then we open it. You get no ask more.
Yeah, it's more like a
Yeah, right. Sounds good. Sign and all of that. So we make it yeah, right. The thing is, we're actually much less secure on books than we used to be because kids don't steal books anymore. It's not worth it. Because it was such an obsession when I was in law school to guard the collection, and now nobody steals books anymore. There's no it's just not, that's how it used to be. So the new law school, so the shelves are just starting to collect. They've gone to so that's fine. Yeah, that's right.
Well, they said that they thought so why don't we get started?
We have a question to kick off the second session.
You said the first time we sort of spoke, you said that the reason that this is sort of a special process is because it's for the public health and there's a reason. And I was just wondering if you could say a few words about medical devices because I feel like it sort of falls in. I don't think Patch sort of applies to all parts of it apply to medical devices. How does that shake out?
Yeah, so medical devices as a third class of therapeutics, if you will, drugs, biologics, medical devices are somewhere in between. Medical devices benefit from the patent term restoration provisions. They can. If you develop a medical device and your patent term ticks while you're still in the clinic, you can't sell, but your patent life is ticking away, you can ask for part of that back, just like drugs can, and just like biologics manufacturers can. There are some analogies between generic drugs and predicate and follow-on devices in the device space. So that notion exists as well. You can, if you're a medical device manufacturer, and say, look, I've reverse engineered essentially another device. I want to get approval based on this predicate device that you've already approved, that you have a safety and effectiveness record with. And will you give me approval without having to do clinical trials or making special showings? There is an abbreviated pathway. It's different from the generic drug pathway. It's called the 510K, I think, approval process. Congress has thought about the same issues in the device space as well. But by and large, I think the device industry is a different industry. It's also patent intensive, but it's characterized, I think, ab initio by more competition. And you don't seem to see the same, I hate to use the word monopoly positions of pioneer manufacturers that you have in the therapeutic space. If you're the first to come out, you're going to be the only one for quite a while. It's different ways by which you can make a bone screw that it's kind of hard to have that kind of market position. Or the first to invent all heart pacemakers so that you have a monopoly. And we can get into this. There are medicated stents, which are, but by and large, they're separate from this scheme, but they deal with some of the same issues. So biologics. Unlike drugs, then biologics are, as I said earlier, they're large molecules, not small chemicals. And they're made in living organisms and not in chemical reactors. And that makes them, at least from a scientific perspective, quite different from small molecule drugs. It makes them, on the one hand, complicated. There are many who say, and the FDA acknowledges that under the current state of science, for regulatory approval purposes, it's very hard, if not impossible, to make one biologic exactly like the other. So when you look at a biologic product, assume an enzyme replacement therapy. There's something wrong with your lungs, and your lungs build up a lot of mucus, which makes breathing. And so the biologic that's being produced in living is the replacement enzyme that you get to inhale, and it breaks down the mucus. The product that's made in cells, and the product itself, when you look at it, it's a murky solution, if you will, that contains all kinds of stuff. It contains the enzyme, but it contains lots of other things as well, like bits and pieces of enzymes. Impurities, it will have a certain impurity profile. The enzyme molecules themselves will be a mixture of different variants of the molecules. Some will have little sugar chains attached to it that the cells put on them during the manufacturing. Others will be kind of truncated and clipped. Others will be aggregated and clumped together, 2 or 3 or 4 at a time. And so this whole mix and gamish, once you administer it, amazingly enough, is able to achieve a therapeutic benefit in patients. And manufacturers, amazingly enough, by tightly controlling their manufacturing processes, are able to produce a more or less consistent product. There are variabilities from batch to batch manufacturer, but they're tolerable to the FDA and they're tolerated by patients, and they're within spec, if you will. Now, if you imagine that 2 manufacturers wanted to produce this, because the production cell lines which are used to produce these molecules are proprietary, they're not shared, they're locked away, they're used in manufacturing, and engineered and fine-tuned in unique ways that require a lot of effort by the manufacturers. So a lot of work goes into this, and they're very closely guarded. They're not everyone's property. The second manufacturer who would want to create the same biologic with its same biologically engineered cell line to secrete the same protein, if you will. And they would have to start from scratch, start at the beginning, create their cell line, create their manufacturing process. And if the current state of science, the end product, in all likelihood, will not be exactly the same as what the first manufacturer produces. The FDA has looked at these issues as well as the industry, and the conclusion so far has been the same, that unlike small molecule chemicals, most biologics are very hard, if not impossible, to recreate in identical form. So that's just the way science works today. Our ability to engineer this is imperfect. At the same time, we are impatient. And for biologics who go off patent, what can we do is that these molecules will finally face some form of generic competition that has so benefited the public in the small molecule space, in the Hatch-Waxman space. Right? There's no pathway. We can't get them to be the same. There's no statute that would allow generic copies or biogenerics. And what are the problems that underlie all this? Well, first of all, if it's impossible to get them to be the same right now, as far as the FDA and legislators are concerned, the first problem with that is patient safety. Can we allow molecules that aren't the same, or medicines that aren't the same, on the market without studying them in patients and to prove that they're safe and effective for their intended use? In the small molecule space, not very difficult. You have one drug, you make it an identical chemical copy, prove that it generally works the same way and is bioequivalent, and then it's probably going to be as safe and effective as the innovator product. In the biosimilar space, if the second molecule is not the same as the first one, how similar will it have to be before we're all comfortable that we can let it on the market without testing it in patients for safety, for efficacy, and so on. So that's the number one concern, really. How can we do this safely? The other concern is what we're going to talk about next, and that deals with the proprietor's rights. Because an argument has been made that, this whole thing between generics and innovators and the balance between market exclusivity for innovators and generic entry into the market, it kind of works because it's premised on this notion that you make an identical copy, fight over the patents, and because the copy is identical, it necessarily also infringes the patents. And then at some point, it all works its way out. And on average, the number right now for small molecule drug manufacturers of exclusivity in the marketplace is something in the range of 13 years for new chemical entities. Despite all the litigation that we've been talking about, the way it works out today, patent protections and everything, is that the pioneer manufacturers in the drug space are on the market for 13 years. So, and that's the second question that poses itself from a commercial perspective. One, patient safety. The other is, how do we divvy up these markets? What do we do to have a sustainable business model for biologics that works the sustainable way it appears to work in the Hatch-Waxman space? So Jay is going to talk a little bit about 4 pieces of legislation that have been introduced to create an abbreviated approval pathway for molecules, biological generics, if you will, and the market exclusivity, the patent, perhaps, resolution provisions that these bills contain, so that we can between stimulating innovation in this other industry, biologics, and patient benefit that may come, or payer benefit that will come from accelerated market entry of generic copies of biosimilars.
All right, I'm going to brave the lectern again, because it didn't go Jimi Hendrix on me at least, but we'll try. So, as you can see, there's been 4 bills introduced before the Congress, really 5. Senator Clinton put a companion bill that's the same as Mr. Waxman's bill, and you can see there's a bit of a range of market exclusivities that are proposed for biologics. So again, these are the so-called follow-on biologics. Again, we don't use the word generic, as we've discovered. You can see there's quite a range, right? There's quite from none all the way up to lengthier periods. In the Eschio and Inslee bill, you get a base period. Then if you discover a new secondary indication for the biologic, so it's sort of a new use for that compound, you get an automatic number of extra years. That's sort of like the new clinical study exclusivity today, only you'd only get one of them, because you just get one. Actually, the way the European variant of Hatch-Waxman works. So I'm not going to talk too much about the patent dispute resolution stuff, because I don't really understand it. Anyways, you share letters, but anyway, so one thing that's pretty noticeable in proposals is that the terms are pretty long. I mean, 15 years, that's approaching the patent term. And of course, that's much longer than the 3 years, 6 months, some of the other talking about before. And it's not the only time. I'm going to sort of segue into more normative views now, if I wasn't doing that already. Congress likes market exclusivities. It's proposed a lot of legislation, and it's thinking about other legislation to create new forms of market exclusivity. So obviously this is something that would happen eventually. Probably our trade representative would try to take it on the road. It's pretty natural why. That's one reason, is that the U.S. is a member of the WTO, and as part of that WTO agreements, largely championed, there are a number of provisions that say patents have to be ecumenical, they have to be across the board, they have to be granted to all fields of technology, and it has to be the same for all fields of technology. Now, what was really going on there, the real politic, was that U.S. wanted its trading partners to adopt patents on pharmaceuticals. The TRIPS agreement, WTO doesn't really say that directly, it just says it more obliquely. And so under the TRIPS agreement, the WTO agreements, you have to treat all patents the same. They all get 20 years, they all get the same term of protection, the scope of rights. Well, that the U.S. Congress, to the extent it wants to remain WTO compliant, its hands tied. They can't say, well, we'll just give an extra year of patent protection to drug companies. They can't do that. So marketing exclusivities are almost irresistible. They speak to market exclusivities, but they don't say very much. So there's a much freer hand. So we're seeing proposals for personalized medicines with market exclusivities, also lengthy terms for homeland security, terrorism countermeasures. And so all these would get sort of longer periods than the market exclusivities we previously. And so, as someone who sort of looks around and stuff on the Hill, it's a noticeable trend. And so, I think one thing that's encouraged me to do is to try to think about, well, why do we have market exclusivities? What's the point of these rights? In particular, remain one of the least theoretically explored of any legal discipline taught on this campus. And if patents are very thin in terms of the research that's been done, and of course marketing exclusivities are even worse. I think there's 4 of us writing on this topic, and none of us is really devoting a lot of attention to it. Of course, the puzzle is, why do we have these things? Congress expressly designed activities to work with patents. Of course, traditionally, copyright, trademark have covered different kinds of things. Right? You didn't get much overlap. Modern technology like software has kind of strained the boundaries, like you get copyright and patent for software. But market exclusivities, Congress work with patents. The question is, well, what do they do? Well, what is their function? Because when we think about patents, we think about promoting innovation. What exactly is the function of market exclusivity? So the paper that I wrote, I'll try to be very brief because I'm not sure how much you're interested in this theoretical exposition. And of course, one of the puzzles is that patents last a lot longer. Right? Patents last longer in most cases than market exclusivities. So if market exclusivities are supposed to promote innovation, they do a pretty lousy job of it. Right? Because patents standing by. In fact, what market exclusivities really do, and especially the exclusivity, is simply to regulate the timing of patent litigation. And you have to wait a while because there's a marketing exclusivity. And at that point, now what did Congress say marketing exclusivities were supposed to do? Not much. Okay, one thing they said about marketing exclusivities with the Orphan Drug Act and again with Hatch-Waxman is that they're intended to encourage people to bring drugs to market when the patents have expired or near expiration. However, that's actually not a predicate to getting a marketing exclusivity. It's not a requirement. Okay, they said it in legislative history, but in fact that's not an obligation that you have to have. So what have scholars said? What have other people said about it? Well, there's only 3 other people, as far as I know, have ever written an article on the topic. And each one of them said it wants innovation incentive. It's really the same as patents. What we're trying to do is encourage people to innovate, to come up with new drugs for new diseases and indications to make our lives better. And I'm not happy with that account. I'll just comment. I think they've all got it wrong. So that's always easy to say, especially once you've got tenure. So why do I feel that way? Well, as a descriptive matter, I think just doesn't work. As a generic, like the generic exclusivity, that doesn't promote patent challenges. Right? It's supposed to rely upon private attorney generals like John to go out and challenge patents. The robust ones remain on the books, the bad ones go off, and now all of a sudden there's competition in drugs. The pediatric exclusivity. The studies don't have to work. They don't have to be successful. There's no innovation in conducting a pediatric study. New clinical studies, these aren't innovative. They're standard studies using known test protocols. New chemical entity exclusivity. Now that one seems to have the strongest argument, but again, its term is so short, it does a pretty weak job. What it really is doing is regulating when you can bring a patent challenge. Drug exclusivity, which again, the notion is, well, let's have people compounds that are promising and actually do the clinical work against orphan diseases. So as a descriptive matter, none of them really seem to do the matter. I mean, to regard as an innovation incentive. What I'd say instead is what they're supposed to do is encourage the clinical trials. Because, again, what I've mentioned before is the patent system doesn't demand much safety and efficacy data to get a patent. You just have to have a minimal sense that the drug would work against that indication. You don't actually have to go all the way to get a marketing approval. And that's a conscious choice the patent system has made. It wasn't something by default. We've decided that. And it's interesting, you can also sort of copy in terms of the length of the clinical trial. You can sort of put together a coherent account. Trials that take a shorter amount of time, like pediatric studies, you get a shorter exclusivity. Something that's an entirely new chemical entity, you get a longer exclusivity. Of course, in reality, all of these terms with the different exclusivities were, public choice theory gives us the answer. They were fought through very on the Hill, and arbitrary numbers were chosen by Congress. But that's intellectual property, right? And where's the 20-year patent term come from? Where does life plus 70 come for copyright? That's the term of copyright, your life plus 70. In most other languages, they say death, which is more descriptive. Death plus 70. But if you sort of put them all together vis-a-vis, you can actually sort of frame the account this way. I think another problem with the account that it's an innovative incentive is that the patent system. The patent system lets certain inventions be patented, but it also patents to some kinds of inventions. And it doesn't do so by accident. It does so by purposeful. We make the decision that something's not innovative enough to deserve the award of a patent. So if we're handing out marketing exclusivities to any kind of drug, even to just doing a study, and saying that that's a patent-like competitor, well, we're thwarting the patent system. We're sort of undercutting it. We're providing proprietary rights in places where the patent system says none ought to exist. So in my opinion, what we really should be looking at marketing exclusivities is not as an innovation incentive, but rather as an incentive to take a known patented compound. You've already filed a patent application, probably had the patent, but to actually steer that through the maze of FDA review. Okay, so that's the purpose. But why does any of this matter? That might seem like a fairly fine line for most of you. Look, if I want a new blockbuster drug, I have to innovate and I have to get FDA approval. Otherwise, it just sits on the shelf. Well, the reason is most of these new marketing exclusivities with their patent-like terms, it's not a surprise. They're founded on the basis that this is an innovation incentive, okay, and that firms in particular industries need these kind of incentives or they're not going to innovate. And again, I find that sort of wrong-headed from the start. I just think that's not the purpose of marketing exclusivities. I know that market exclusivities don't have to just serve one purpose. New ones could serve new purposes. But it would take market exclusivities out of the orbit where they traditionally resided. It would also mean the patent system would simply remain unaddressed. It would mean that the patent system has problems that these industries encounter, but we're simply not concerned about them. Instead, we're going to create sort of satellite intellectual property rights that would seem to proliferate without limit, right, and with terms that really have an uncertain effect upon our public domain. So at the end of the day, I'm somewhat dissatisfied by the account. And I'm concerned. I'm a concerned observer about the ease with which these intellectual property rights can be generated, and sort of the fact that we really don't know how to calibrate them very well. So I guess I would just close by preaching some caution as these kind of limits are proposed by so many. Okay, now other pods may have some different, and I look forward to hearing them.
It's, assuming we have about 15 more minutes, so let me do this. And, what I agree with and what I disagree with. It's always easier to start with the things you disagree with because they're so in your face. So maybe I just start with the term marketing to begin with. I'd say, I think marketing, to call these things marketing exclusivities, to my mind, is a bit of a misnomer because they exclude anybody. What they exclude is a who wishes to gain abbreviated approval based on innovator's data. An important thing about these marketing exclusivities, the 5 and 3-year exclusivity under Hatch-Waxman, is that you can walk into the FDA with 2 applications. One would be an abbreviated new drug application. You walk in there and say year 3 or year 2, or on the day the innovator got approval, and say, I want to file an abbreviated generic new drug application. Will you let me? And the FDA will say, you want the benefit of the innovator, quick approval for your own thing without doing your clinical studies. Is that correct? I say yes. And the FDA will say, come back in 5 years. You have to wait. My other application is one that was generated on my own clinical trials. I redid the whole thing. Spent all my money, and the FDA would say, come in, we'll review it. The 5-year exclusivity or the 3-year exclusivity doesn't bar you because you've done all your own work. Okay, so that's an important distinction, actually. The marketing exclusivities, with the exception of the orphan drug exclusivity, but the regulatory exclusivities operate against people who seek abbreviated approval based on somebody else's approval, somebody else's data. So that's one thing. They don't confer, and the Food and Drug Act nowhere has a right to marketing. They operate as a constraint on the agency. Their regulatory mechanism they can be thus described, even though they do have value. The other thing is to call them intellectual property rights. I just better get that out of the way. Marketing exclusivities, they sit somewhere in the food. We call them data exclusivities. And again, they operate as a constraint on the agency. So the agency looks at an application that comes in. It asks, does this rely on clinical studies that were not done by the applicant? And if it does, then the agency does A. And then the agency does B. So, the agency operates by rules. And the data exclusivities or the marketing exclusivities that we've talked about are such. They operate on the agency. These marketing exclusivities aren't rights in the sense that patents are rights. So, if I'm the innovator, I don't have a certificate that says Certificate of Marketing Exclusivity that I can go and enforce against anybody. In fact, I don't have a private right of action whatsoever. The FDA will enforce this, or it won't. And if an administrative lawsuit, because the FDA is supposed to follow its own rules, but it's not enforced. It's not a right that I can convey, that I can sell to anybody. It's not the marketing exclusivity is not a right that I can license out. I can license the right to refer to my data. But marketing exclusivity is in any way. It's not like a patent. I cannot sell it, I cannot use it in divorce or devise it to my children. So just these 2 things that I think just typologically are important to keep in mind. So now we've also wondered, and I've wondered about what marketing exclusivity do. Why are they in the Food and Drug Act today? And why do we discuss their creation in the follow-on biologics context when we have patents? And one thing that Professor Thomas said, I think that we want to explore further. I just want decorum. That we want to explore further the discussions is, so are they really necessary to incentivize clinical trials? And if I'm a drug manufacturer and I have a patent that's going to live for years, is 5 years of data exclusivity that's going to run concurrent expired by the time the patent expires? Is that really going to make a difference? I have a patent that runs for 18 years. That's going to be my driver. If I get 5 years that run, that's not going to make a difference at the end. I'm caring about the not the front end. So why would I do this? Maybe I would do it. I have no patent whatsoever, and the exclusivity or regulatory exclusivity or the marketing exclusivity, as you might call it, is the only thing that protects me when I go to market. I develop a drug that has no patent. People actually do that. If you go to the Orange Book and you look at new chemical entities even, so completely new drugs that have never been approved in man, about 15 to 20%, surprisingly, have no patents whatsoever listed. Somebody went to the trouble, probably with the help of orphan drug exclusivity too, and said, you know what, the value proposition is worth it. I can model this. I can do the cheaply because it's small patient populations. The FDA will cut me some slack because so it's relatively cheap clinical development. And then under that scenario, it's for me to do this with the expectation that I will be exclusive on the years and recoup my investment. Yeah? Or sometimes it even works with a 5-year model. You benefit only from new chemical entity. But for the most part, it's the patent term, and you're going to look for longer assurances to recoup your investment. Because the investment that's necessary to bring a new drug or a new biologic to market right now is calculated to be in the range of $1.1 to $1.2 billion fully capitalized cost. So it's a lot of money to bring a new drug to market. It takes some time to recoup this fixed cost, the fixed upfront investment, and not every drug recoups that. In fact, many don't. Many drug manufacturers don't make all the money back that they spent in development on any given drug. It comes back in the aggregate, but not per drug. Okay, so here we are. Patents seem to be the most important driver, but yet we talk about these long data exclusivity. That when we have a patent system to incentivize innovation, what are these guys supposed to do? And Jay gave you a historical account of the Hatch-Waxman Act. I also want to give a historical account briefly because it helps to look at what was actually done in 1984 when this pathway was put in place, when we created an abbreviated pathway for generic drugs. So in the early 80s, Congress looked at the country and saw that there were a lot of innovator drugs that were apparently off patents. They're numbered in the hundreds, 150, higher by some counts. And that was obviously, from a societal perspective, undesirable. These manufacturers kept charging innovator prices, and these drugs were off patent. In every other industry, you're going to get at some point. Someone's going to copy your stuff and start underselling you. And that wasn't happening. The reasons were many, of course. But the basic reason is that drug development, I just said it, is a very expensive and risky proposition. And even for a drug that's already been proven to work, if you have to do clinical trials and all that upfront investment, for many drugs, it's not worth it to redo the whole thing just to be second on the market. Are you going to spend $1 billion developing a drug that's second in class? You might not be able to make enough money because you have the innovator there to already compete with you. And so, that might not work from the manufacturer's perspective. From Congress's perspective, same thing. That's pretty undesirable. Somebody who goes to market like that, $2 billion getting there, is not going to be able to charge prices low for Congress to achieve its goal of really driving price competition. Better access. It doesn't make sense. The best thing you're going to create is some kind of duopoly where both spend a lot of money and they're both selling within 10% of each other. And patients lose because they end up paying the same thing. So at such high development, what you're going to do basically to drive drug prices down, that's what Congress said to us. We want to have a mechanism by which many generics enter the market, they compete with each other and the innovator on price. That's really going to drive prices down. And in order to accomplish that, we have to make generic drug development as cheap and as risk-free as possible. See, we cannot require the same upfront investment that we impose on the innovator. And what we're going to do, Jay said it, is we're going to create an abbreviated pathway by which they don't have to do full clinical trials, but we will allow them to get approval based on the innovator's approval. And this is really, I need to drive this home, quite a that happened. That happened in no other industry. Congress looks at one industry and says, we're going to require you to spend all this money as your admissions ticket to the market. It's the innovator pharmaceutical industry. You spend so much, that's how much it will have to be. Then you get your license to sell your drug. At some point in time, we're going to take the benefit of that investment that we required and make it non-excludable. Basically, we're going to take that benefit and make it available to everyone, rent-free. paid for the privilege of relying on your approval. And so Congress made a very deliberate choice that they don't make in other industries. And they did so very deliberately to create a public good. In this area, this is of such overwhelming societal value that we're going to do something that we're not doing with any other industry. Basically, they created what in commercial terms, or economic terms, is called the free rider situation. And I wish I had a better word, because free rider has really a pejorative connotation that I don't intend here. I intend to use it in its economic sense as a free rider is somebody who benefits from somebody else's investment without making a corresponding contribution himself. And the free riding puts the other in a worse situation than what they were in before. You had a question?
The investment made, I mean, that's an investment that the public has carried. In large part by very high prices having been charged over the period of the patent. And so to suggest, I think, that the company has laid out all this money when it's recouped those costs and a lot extra, it's the public that has subsidized, or effectively has paid for the research and a lot more, and is now saying we're not prepared to pay again for the same research to be more likelihood would be unethical in the first place.
I agree. Let me see. You said the words, the investment has already been recouped. And that's a very important, and that should be a you only do this if it's relatively sure. So you want to do this in a way in which the innovators, of whom the investment has been required, are going to be able to recoup. Only then does this begin to make commercial sense. And Congress probably felt in 1984 that in passing the Hatch-Waxman Act, they kind of accomplished it. They don't want to put the pharmaceutical industry out of business any more than than putting any other industry out of business. But yet, they've done something unusual. They've said, we're an investment, and at some point, and we don't do this with any other industry, we said that investment is going to be made available to everyone to benefit from. And other industries, don't have industries face normal competition in normal contexts. It's also true, by the way, that I think in all fairness, that the investment in new drug development is not only the innovators or the drug companies' business. University researchers contribute, patients contribute because they don't have for clinical trials. So drug development in some respects is a societal endeavor, and all contribute. But the drug industry contributes too, in the form of, they pony up the money, they organize all the clinical trials, and at the end they spend like $1 billion. And they need to make that back. On many drugs they do, on a lot of them they don't. And so we keep going. I want to cut this short. So what do? I'm just going to get straight to my thesis. And I will tell you that this industry is unlike any other industry with respect to both the benefits that Congress convey and to transfer. It doesn't happen in other industries. There is no free rider in the value neutral sense in which a free rider situation like that in any other industry. It was here created by statute because we've decided it's of societal value to do so. And there are many, many special patent rules and special patent litigation provisions in the pharmaceutical industry and in no other industry. So this are special provisions. Data exclusivities to you come in for a special reason that relates to the free rider problem or the free rider scenario that Congress decided to create. I'll leave you with the following notion. Patents are supposed to promote innovation. And patents do so by preventing copying of the invention for a limited time. Free riding, the transfer of is a different thing. That I submit you all minds. You can be a patent infringer and not free rider on the inventor's investment. And you can be an economic free rider and not infringe somebody's patent. Let me give you to illustrate that point. And then I'm happy if you go home remembering it. Roche Pharmaceuticals and Amgen Incorporated. Amgen is the second biggest biologics manufacturer in this country, and Roche is a big multinational pharmaceutical and biotech corporation, are in litigation over patents and products. This dispute, Amgen has long-standing patents to its blockbuster drug, Epogen. And Roche has, at great expense, developed another erythropoietin product that's in the same class. It's really close to Epogen. But it's chemically modified. It's not exactly the same, and therapeutically there are some differences to it. Amgen's Epogen needs to be given frequently to patients, get injected every other day or something. Roche's gets injected every 2-3 weeks, so there's a difference there. Some therapeutic differences. So Roche developed this whole thing from scratch. And yet it's been found to infringe. And so from the judge's perspective and from a patent lawyer's perspective, Roche copied because it infringes the patent. But they spent like $1 billion developing this thing. But, they copied, but they didn't write free. They didn't benefit in any way from Amgen's investment. So you can be a copyist and not a free rider. You spend all the money on your own. Data exclusivities don't prevent that. The FDA accepted Roche's application. Even if Roche were a drug, the FDA would have accepted it. Roche spent its own money trying to get de novo approval, and yet they infringed the patent. Patent infringer, but not a commercial free rider or an economic free rider. Conversely, you can be a free rider, seek the economic benefit, and not infringe the patent. It happens all the time. For example, in the generic drug context, where you go to court and you say, I have a formulation patent listed and it's not very good, and my formulation is different. After all is said and done, agrees and says, yes, you're right. You didn't infringe. They have a patent, you didn't copy. And you get abbreviated approval. You still get the benefit of the innovator's data. Right? So patent infringement and economic free riding. And the data exclusivities come in situations where an applicant goes to the FDA and says, irrespective of patents aside, I seek approval based on somebody else's data. I want to take advantage of the free riding provision in the statute that was given me. And that's where the data exclusivities come in. Pharmaceutical manufacturers will tell you, and biotech manufacturers will tell you even louder, that they need protection from two things. They need protection from copying, and they need protection from free riding. And both are innovation killers. This is what we will hear as this debate heats up. Patents prevent the act of copying, and they are necessary for protection. Data exclusivities prevent the act of free riding, benefiting from the other's upfront investment. Both are needed. In practice, so goes the account, and the two run concurrently, even up to 14 years, or however long the patent term is. In practice, that's not going to make a difference if the two products are so close until it's copying. But what we're about to do in the biologic space is because we can't have the two molecules be identical. There's going to be more jitter. There's going to be the concern that the innovator's patents that cover only its own product are not going to extend out far enough to cover the follow-on, which doesn't have to be identical. It can be different. We don't know how different it will be allowed to be. So that's really the fear that I'm hearing from my members when they look at this situation. It's like, okay, so there's copying fears, and there's the even bigger fear of free riding on the upfront investment. So I would posit that that as an alternative account for data exclusivities is that they are intended to deal with a very specific free rider problem that comes created by statute in the Hatch-Waxman Act. It is about to create in a different form for biologics. And so thank you very much for your attention. Maybe we have a little time for discussion.
This is a great kernel. Like on our other sessions, you've gotten to hear people who are right in the front lines of this hot issue on Hill. We've got about 7 or 8 minutes, so I guess I'd like to start with the students in the colloquium first with questions, and then we'll still also have a reception at the end too if you want to come up.
Yeah, I will also start the reception. So to the extent you have questions for Jay,
Well, that's right. That's right. So why don't we start off questions from the students?
It sounds like you're a marketing exclusivity skeptic. Any of these proposals, do you think?
Well, I don't disagree actually with Hans. It seems over much. It just seems to me the length of the marketing exclusivity ought to be founded on the difficulty of the clinical trial. And I've got no evidence so far these clinical trials will be 3 times as difficult as any other clinical trial that's been done. So simple as that. So I'm not in favor of the Waxman bill in its entirety, but it just seems the other terms are beyond to be compensatory for the trials.
yeah, we're right now a bit agnostic as to their length. That's for purposes of the current discussion. In Congress, they are. In Congress, it's every month counts.
You just said you don't think the clinical trials for the following biological will be 3 times as bad as for generic drugs. Is there any indication of where they came up with the 12, the 14, or the 15 beyond throwing dice, or is there a special interest that was seeing how much it could get?
The best I can come up with is the 14 years is based on the maximum term of patent extension under Hatch-Waxman. So the argument is, well, Congress has already approved 14 years of patent protection, 14 years of data exclusivity. Of course, we see a little bit more of upward motion in the Inslee bill. The argument is, of course, that's the maximum period of term extension. Not all products get the maximum. As well, these terms aren't exclusive of patents. Of course, biologic firms will eke out as many patents as they can get, and the record shows they're very successful in enforcing them. For example, Columbia University's co-transformation patent that covered 75 some drugs and 35 some companies. So I find that argument very weak. But to answer your question, that's the basis for the term.
Okay. If the biological firms don't think this is a good idea, who's pushing the idea? Who thinks this is better than sliced bread?
Let me see.
Well, the brand
Two
name
quick
firms
answers.
are-
By and large, I think biologics companies do think longer data protection is necessary. And it's not even only right now there is only such a thing as a brand name biologics company. But even companies like Novartis, big multinational drug maker and biologics maker that operates in both areas. Through their Sandoz division, they will get very involved in biogenerics or biologics. So companies interested in creating follow-on biologics look at this and say, what we ought to have is a period of data exclusivity that runs up to X, and then it ends, and then we should have as little complication as possible for market entry. So, one thing that people are concerned themselves a lot about is to make the transition smooth. Brand name expires at some point, and then generic entry is going to be easy. Right now, under Hatch-Waxman, it's not easy. Under Hatch-Waxman, there's endless litigation before anybody gets on the market. It's like long and painful and difficult and complicated for everybody. So, one thing that people are looking at is, in return for making this easy, will you give us a couple of extra years? The other data point, by the way, in addition to the 14 years under Hatch-Waxman for patent term extension, Other data points that have been used are economical justification that have calculated an economic break-even point of around between 12 and 16 years for biologics once they so that's kind of like an interesting approach to say, let's look at market realities when companies recoup their investment. And of course, that's scrutiny. The other thing that's been looked at is what do they do in Europe? In Europe, they're actually ahead of the U.S. for biosimilars legislation, and they've arrived in the 10 to 11 year time frame. So that's one thing to look at. And the final thing to look at is the de facto market exclusivity for brand name manufacturers today. If you bring a new chemical entity to market, if you just look empirically, day from new drug approval to generic entry, about 13 and a half years empirically. So biologics manufacturers say, well, okay, drugs, for whatever reason, are on the market exclusively for about 13 and a half years. So that's kind of like what we're asking for. That's what they're saying. So they're pointing to all these things, and they all fall into the 10-year plus range. Of course, there's a big interest in justifying these data exclusivities.
I have time for one more.
I was just curious about the pediatric exclusivity, and I'm wondering if there's anything in Hatch-Waxman or perhaps some of these other proposals that prevent sort of the repeated claim of additional research that's being prevent this sort of like ongoing exclusivity.
At least one of the bills expressly acknowledges the existence of the pediatric exclusivity and would allow the 6 months to be appended onto, for example, the 15 years.
But only once. I think, under Hatch-Waxman, the repeated exclusivities, there are different exclusivities, and some of them run concurrently. So you can get a drug approval, you get orphan drug exclusivity, and new chemical exclusivity. And new chemical exclusivity expires, and then orphan drug exclusivity expires after 2 more when you hit the 7 years. The only thing that you can get repeatedly is the new clinical study exclusivity. When you have a drug and you do a new clinical trial, drug application approved by the FDA, and your clinical studies were essential for that, then you get like a bonus for that. A generic can sell your drug for the new indication that you got approval for. So the scripts, whatever they want, but if you got approval for like a change in formulation, that's more difficult. In that case, the generic can sell the old version of your drug, but not your new and improved version, for which you had to do clinical trials.
Like the once daily formulation. They can sell the 5 times a day.
Well, let me just say, while we are the 2 speakers here, you've all been treated to the kind of briefing that a number of times is genuinely interested in the subject matter with Don. You guys, this is an issue that's not theoretical. It's not down the road. This is an issue that's really immediately it's on the agenda. Not this year, but certainly next year. It's also something that gets right to the heart of what we talked about a little bit last week about how do you think about health law in the context of the government creating incentives for the behavior of private industry. In this case, it's obviously a complex interrelationship between private companies and the science. But I would just ask you to think about what an amazing, we have to think our speakers, but just to think through this as a way in which the law is a tool to affect the public's health. So let's first give a round of applause. The action papers, I'll take the advice from last week. We will, first off, the action papers with Susan, but also I won't ask you to, I would ask you all to have a general reaction, but I would ask you to engage directly on this issue. So thank you very much.
Thanks,
I just have one announcement for the students for the Colloquium. Yep. I have hard copies of, the syllabus and the readings for next week are up, but I have hard copies of one of the articles, and